Right, we're going to start. Good morning, everybody. Hello and welcome to the penultimate Women in Sectional Title webinar for 2021. We really value your participation. Our platform aims to educate our participants and to foster a real sense of community, a sense of support, and above all, a place to share, learn, and grow. It's lovely to see everybody. We've had a really good turnout. In fact, this week we've registered the most participants that we've ever had at our sectional title webinars. So thank you for that. Women from all over South Africa, and it looks like Australia as well, have come together and said, this is a forum we want. We want to create something where we get together, we use our energies, we engage with each other, and I think that is just going to spur us forward completely. And the people helping us are our sponsors. So I'm just going to read to you who our sponsors are and what they do. Thank you, Zedfin, your specialist finance company providing smart solutions for community schemes. CIA, as one of South Africa's largest community schemes insurance providers, CIA understands the growing challenges faced by bodies corporates today. MeetingPal is a system specifically developed for the management of virtual meetings for sectional title schemes and homeowners associations in full compliance with the Sectional Title Schemes Management Act. BCM Track provides innovative scheme management software to community scheme managers. And Sectional Title Solutions, last but not least, is focused on providing value-add solutions to community schemes nationwide that reduce costs, generate revenue, and increase property value. And this is what it's all about. I mean, as owners, as trustees, as attorneys in this industry, we need to look at asset value, increasing asset value, protecting these gems, these sectional title schemes, and owners are going to look to us. I know there are quite a few trustees on at the moment, and I'm very happy that that's the case, because today we are talking about what trustees' duties are, what their legal position is, can they just take resolutions, what can they do and what can't they do. So that's, let's get the show on the road. Okay, sorry, this isn't right. So trustees of a scheme are tasked to make decisions on behalf of owners. But what rights do owners have to challenge these resolutions? And what resolutions can owners themselves be involved in taking? Over the last year or so, I've realized that there's quite a disjunct between what trustees perceive their role to be, what owners perceive the trustee's role to be, and how owners view themselves. And very often, they don't think that they've got any power to change anything. In fact, in a radio interview the other day, one of the owners said to me, well, this body corporate is, it's just going in one direction. Can't we place the building under administration? What can we do? We feel completely helpless. And the answer I gave to this lady was that, well, actually, you need to take charge. You need to get back control, and you need to understand what your rights are and what you are doing in this complex to make it a better place to live and to increase your asset value. And so many owners don't understand that. There's also become a more fractious relationship between owners and trustees. Again, last 6 months, particularly of this year, we've seen trustees becoming bullies. We've seen a lot of the owners complaining about things being imposed on them in a sort of draconian kind of way. It's all about tone and manner. And I think that there's a balance, because more often than not, those people who are complaining are people who don't like the imposition of rules on them. So there's always a happy medium. I'm going to start now with what resolutions owners can take themselves. So let's place the owners squarely in the picture before we talk about trustees, before we talk about their quite exciting case that I wanted to tell you about. Owners have the right and the obligation to make ordinary resolutions, special resolutions, unanimous resolutions, and then there's a case where you need the written consent of every single owner for certain things. But all of this information is in the Sectional Title Schemes Management Act. And very often it's really not easy for any of you to sit and extricate where this says what section is this. So I'd like to try and make it as easy as we can. What decisions require an ordinary resolution? An ordinary resolution is 51% in terms of the Sectional Title Schemes Management Act. Okay. First one, installing separate meters for electricity, water, or gas. And I think that is, that's just a normal meter. It's not a prepaid meter. We're going to go on to prepaid meters. And I think this is an increasing trend in sectional title developments where you want separation. You want each person to have their own separate way to gauge water, electricity. While we're on this point, I just need to tell you about a very exciting case. We had it yesterday. So everybody knows, and the CSOS directives say that you can't cut electricity to a unit. The body corporate can't cut electricity if somebody is in arrears. Well, if you take a court order against somebody in arrears just on electricity, the courts at the moment are actually disconnecting. We've been able to get quite a few disconnection applications. And about a few weeks ago, we got an order for disconnection, and the owner got an attorney involved and took us to court to say this disconnection order is not valid. You're not allowed to disconnect. And yesterday we got the case heard again and won. Basically, you are allowed to get a disconnection order through the High Court, and that is what we've been doing. So just so that you know that. Right, another thing for an ordinary resolution, remunerating trustees who are non-owners. So if any of you wanted to nominate me as a trustee for your complex, the only way that you could do that is to get 51% of all the owners to agree. And you'll see when we go into special resolutions that it's actually quite a sort of low amount of votes that you need to appoint somebody else as a trustee. We also know that you can have all non-owners as trustees. There's no proviso anymore which says that you have to have the majority of owners to be trustees. I think it's important, by the way, I don't want to be the trustee for any of your complexes, just in case you're wondering. Okay, the third, appointing a managing agent. Owners, 51% can direct the trustees to appoint a managing agent. But of course, we also know the trustees can by themselves appoint a managing agent. So those are the things. And of course, on a daily basis, your ordinary resolution, if you're in an AGM or a special general meeting, could be about anything that's operational. These are specifically mentioned in the Sectional Title Schemes Management Act. All right, special resolutions now. Special resolutions, we obtain 75% in number and value. And these are the ones specified again in the Sectional Title Schemes Management Act. Firstly, you need a special resolution to lease common property for less than 10 years. So this is a situation you have where you've got a common property area and you want to lease out parking bays. And they haven't been registered exclusive use areas. They're not rule created exclusive use areas. It's just pure common property. And you're allowed to do that, but it's not a trustee decision. You need your special resolution. Okay, then installing prepaid meters, not just normal meters. That is for water and electricity on a section or exclusive use area. That would be a special resolution. And just remember the 60-day proviso. So you've got to give notice, 60 days notice to people if you want to put prepaid meters in, to say what the cost would be of those prepaid meters and what the implications would be for the body corporate going forward. Borrowing money, special resolution, your body corporate having a problem. In the old act, you needed a unanimous resolution to borrow money. So the new act has actually made it easier to borrow money because you need a special resolution, creating a servitude. If there's a right of way that somebody wants across an area of the common property, a special resolution, extending a section. This one we all know. And I have to say in practice, well, certainly in my practice at the moment, this is becoming every second day thing for us. We're seeing this all the time. People wanting to extend, possibly because they don't want to go out and buy a new property, but they want to increase the size But remember, it's not only a special resolution. You need to extend a section. You also need the land surveyor to come into it. You need permission. You need to get drawings redrawn so that your participation quota can change. Amending conduct rules, we know, also requires your 75% in number and value. The other day, I had a case where the trustees had amended the conduct rules and were trying to get a compliance certificate from the community scheme ombuds service. So yeah, that's not on. You need your owner's involvement in that. Purchasing, renting out, and selling a unit and owned by the body corporate all need special resolution. So here you would find the situation where a body corporate has sued somebody, they're in arrears with their levies, and the body corporate decides that instead of taking the risk of getting somebody else who doesn't pay their levies, they would like to actually buy the unit and rent it out. And it does happen, and it's increasingly happening. So here, trustees won't be able to deal with that. You buy a unit, you need your special resolution if you rent it out, and if you mortgage it, you're also going to need that input from the body corporate. Remunerating trustees who are owners. So you see, it's harder to actually decide to remunerate trustees who are owners. It's 75% as opposed to 51%. My view, and it's always been this way, is that I don't really believe in remunerating trustees. And as harsh as that sounds, as soon as you start remunerating trustees, whether they're insiders or whether they're outsiders, there's certain expectation levels that you have. And you start putting pressure on people and fights start. And I think trustees, as you know, is a civic kind of duty. It's your duty to protect your asset. But I mean, I've got quite strict views on that. Appointing an executive managing agent, special resolution again. Yes, how else can you appoint an executive managing agent? Well, it's in the Act that says if you get 25% support of your body corporate members, then you can approach the CISO, the Community Scheme Ombuds Service, to appoint an executive managing agent. But you can force the trustees, if you're getting this type of resolution, to go for an executive managing agent. Terminating your managing agency agreement with 2 months' notice. The other side of that, though, is that the trustees, if there's been a breach of contract with the managing agent, the trustees can terminate as well for breach of contract. And they would then have to, they make themselves open to or vulnerable to a damages claim, but it doesn't exclude the trustees from being able to make that decision. Interesting one, cancelling notarial registered exclusive use areas. So if you want to actually create a registered exclusive use area, you need a unanimous resolution, but to cancel it, all you need is a special resolution. And then effecting reasonably necessary improvements on common property. Another one, going crazy on my desk at the moment, is everybody trying to do different things on common property. Security is covered under this, geysers, solar panels, air conditioning. What's reasonably necessary? You need to then, get these kind of resolutions for that. Decisions require unanimous resolution, and that's unanimity once a quorum of at least 80% is reached. While selling common property. Again, this has also become a bit of a trend where bodies corporate require money and they've got a piece of land within their scheme which they don't want to utilize for parking, but unusual actually, but they don't want to utilize, or they've struck a deal with an advertiser who wants to advertise on common property, but they don't want to get all the permission, so they would rather sell the common property. It's a big deal. So you need a high number of people to vote. Leasing land outside the body corporate. We've had that situation where one of my schemes leased the parking area of a shul next door for parking. But again, not an easy thing to get right. I mean, you guys know, unanimous resolution, literally impossible. But if you don't get a unanimous resolution and it's required in the Act, which all of these are, then you can approach the Ombuds Service to override that. Leasing common property for more than 10 years, very unusual. Creating a registered exclusive use area, that's in our book, we call it a number 1 first prize exclusive use area, which is your own property right. It's capable of being bonded and it's capable of being, sold as well. It's got a value. Amending your management rules. Your management rules are like your big brother rules, your important, serious kind of rules. The conduct rules, on the other hand, can be amended, as we said, by special resolution. Amending management rules becomes literally impossible, mostly in my experience. Loaning money from own account, that was also something that was made a unanimous resolution, but I think it's become pretty redundant at this stage because of the reserve fund, which people have been forced to create. Agreeing to extend the time period of a Section 25 right to extend. This is really where you've got a developer who's got a whole big piece of land. They only want to start with one phase. At the beginning of that phase, they register a Section 25 right to extend. And they say, well, we're going to take 25 years to complete this. 4 years comes and goes, and all of a sudden they realize, sure, but we need another, 20 years or 10 years to extend this right. They can't do that by themselves. They need to come back to that body corporate. And the body corporates are often becoming difficult about giving developers the rights to just carry on ad infinitum, because if the developer loses that right or doesn't do it within that time period, then the right to develop then vests with the body corporate. So that's favorable to the body corporate. And effecting not reasonably necessary improvements on common property. Those would be luxurious improvements. At the moment, I can just say from a practical point of view, like a tennis court, for example, and I've got a case now where they want to take a tennis court and turn it back into something else rather than use it as a tennis court. What resolution would you need there? And I argue that you would still need a unanimous resolution to change it back from what it is to the tennis court. Okay, what decisions require written consent from all owners? Here there are three main ones. Buying land outside the common property, so that's if you want to buy land and incorporate it into your scheme. Also not really very common. Selling a right of extension of a scheme to a third party. So this is where we were talking about the developer with the phases. At the end of the day, if a developer's run out of money and they want to get a friend in to come and develop that phase, they can't do that without the written consent from all owners. And they can't also just give that right to somebody else and that person can do what they want, because at the beginning of a Section 25 right, it will be recorded what can be built there. So in one of my cases, it was in Bruma, very early on in my career. The developer ran out of money. His time periods were running out. He wanted to give the building to somebody else. And then somebody else wanted to come and build like a dancing school conference center within the scheme, because they thought that would be a good way to make money. Not allowed to do that. They needed the written consent. Their time periods lapsed. The right vested in the body corporate, and the body corporate got their own developer to develop what was set out in the first place. Okay, the third one is also something on our radar every day, allowing exclusive use areas to be utilized for something different than specified on plan. So you're going to need the written consent of all owners to change a garage into a small shop catering business which caters for everybody in-house in your scheme, or a hairdressing salon in a garage. And I think that's right. I really do, because you buy into a complex and you see what you're getting, you see where the lay of the land literally, and then everybody starts making all these changes to the scheme. Okay, trustees now. Let's go on to trustees. We've spoken about owners, so you can see that owners really do have a lot of say in the scheme. Trustees, I'd like to take you to the bottom 2 points. In general, trustees control, manage, and administer the common property for the benefit of all owners. And trustees have to do all things reasonably necessary for the enforcement of the rules and for the management and administration of the common property. That's a big ask. In saying that, look at the top things. They have to establish the fund, a reserve fund. They operate accounts. They ensure the building. They ensure compliance with the rules. Huge job. They maintain the property, in my mind, the hugest job. And they employ people. They've got to control all the labor relations issues as well. So These are the things, apart from other things that are in the Act, I can think of trustees, you need trustees' permission to consolidate or subdivide a unit, things like that as well. So they do have a lot on their plate. Not only that, we've got Regulation 14 of the Community Scheme Ombuds Service Act, which talks to us about the scheme executives' roles and functions. Scheme executive being a trustee of a sectional title scheme or a director of a homeowners association. And it says you've got to take reasonable steps to inform and educate yourself as a trustee about the community scheme, its affairs, activities in the legislation and governance in terms of which the community scheme operates. You've got to take reasonable steps to obtain sufficient information and advice about all matters to be decided by the scheme executives to enable yourself to make a conscientious or informed decision. You've got to attend all meetings unless you're excused on reasonable grounds. You've got to exercise an active and independent opinion with respect to all matters and exercise due diligence in preparation of meetings, attendance of meetings. 2 over there, Clause 2 says the obligation, the community scheme obligation, the executive's obligations are in addition to and don't derogate from the fiduciary obligations of a scheme executive in terms of the common law or any applicable statute. So we've got the fiduciary duty of care and skill. You can be sued if you breach that fiduciary duty, but over and above that, you've now also got all these steps to take. When you take decisions, like we're going to talk about this trustees resolution, when you take decisions, those decisions must be well considered. They must be thought out. If you don't know what the answer is, you need to seek advice. You need to speak to your managing agent. You maybe need to speak to an attorney, or you need to speak to somebody experienced in this business before you make decisions that are going to get you into trouble as trustees. Can trustees be limited? Yes, because 2 things. Because of the fiduciary duty, they are limited. They can't act unethically. They can't get their brother-in-law to get the painting contract in the scheme unless everybody consents to that. They can't get their garden maintained beautifully while the gardens on the other side of the complex are neglected. They've got to act ethically. They can't wear too many hats. They're also restricted in terms of the AGM restrictions and directions. In terms of money, they can't spend X, Y, and Z unless they revert back to an owners meeting. I mean, you've heard these things 100 times, but it always helps to get things, to be refreshed and to hear them again and again and again, because that's really the only way that a person learns. So when I saw a case that has come into play now, that went all the way to the Supreme Court of Appeal, I thought it was really a great opportunity to work through with you, around trustees' resolutions, how people make decisions, what courts can do, what the Ombud can do about that. And this is the case that we're going to be talking about. Bay Estates and Escapes, they are a letting agency, versus the trustees for the time being of Legacy Body Corporate and Pam Golding Property Management Services. So Legacy Body Corporate, obviously represented by the trustees, and Pam Golding Property Management Services were the respondents in this case. And the applicant is this letting agency who really, really got very, very upset with the trustees in this building. The matter was originally heard, or the decision came down on the 4th of February 2020, and that's at the Western Cape High Court. Okay, it's a tricky case, a lot of technicalities, so I'd like to really take you through this pretty slowly, and we'll just repeat things as well. And if you still are concerned about it, please never hesitate to contact me. I can take you through it again. So there was a conduct rule that was properly instituted and properly agreed and voted on. The conduct rule said the trustees have the power to restrict short-term letting to only those which were in the sole discretion of the trustees, managed by reputable letting agencies. Okay, now off the cuff, I can tell you that this is a very dangerous rule already, because when you're placing all this discretion into the hands of the trustees, strange things can happen. Trustees determined that Bay Estates and Escapes were not finding ideal tenants. There were noise nuisance complaints, so they sent them a letter to say that they were not permitted to operate in the scheme. Bay Estates filed an application to review the resolution of the trustees in the Western Cape High Court. So let me just flesh this out a little bit and tell you a little bit more about the case. So the letting agent found a tenant for the owner who lived in Johannesburg, and the owner made an arrangement with the tenant that the tenant would be allowed to sublet on an Airbnb basis Unit 107 of Legacy Body Corporate. So the relationship there, or there's a problem there, because the relationship is not between the Bay Estates and Escapes and the body corporate. It's actually between the owner and the body corporate. And this owner was giving the permission to his tenant, who just happened to be found by Bay Estates, to be doing all these lovely Airbnb things. And in September of 2018, I think it was, of 2018, they let the unit out, and it became a problem with these Airbnb people coming in. They were flicking cigarette ash all over the balcony downstairs. There were noise complaints, and this increasing noise complaints till May the next year made everybody very upset. So they decided to take their conduct rule and just say, well, okay, Bay Estates, you're not actually reputable. They said that in inverted commas, so you're not allowed to act within the scheme anymore. Bay Estates got upset because there was reputational damage, and they went to the High Court for a review application. So what is this review? Let's talk about review. You've heard about appeals, but reviews are something which mainly attorneys really hear about or know about more. If you cast your mind back to the old Sectional Titles Act, Management Rule 71 specifically, where it gave the body corporate a right and owners a right to arbitrate in terms of the rule where there was a dispute between the owners and the body corporate, or between the body corporate and the owners. That management rule said that you weren't allowed to take anything on appeal, any order of the arbitrator on appeal, but you were allowed to take it on review. So just generally speaking, don't even read what I've said there, just listen carefully. Generally speaking, review is when you're not looking so much at the merits of the matter, but you're looking at the process that was taken for this matter to come into fruition, or to be an award to be made. Was there bias? Was everything procedurally correct? Was there, did the people making the decision exceed their powers? That's what you look at with review. And there are two ways to look at review now in South African law. The one is a resolution in terms of an administrative act under PAJA, which is the Promotion of Administrative Justice Act, that came in 2000. And the second way is a resolution reviewable under the common law of general principles of lawfulness, reasonableness, and procedural fairness. That's one that makes most sense to you and me, I'm absolutely sure. The Promotion of Administrative Justice Act came into being because people didn't like, the legislators didn't like the way that the government or public bodies or forums were making these draconian decisions, quite arrogant decisions, and sort of getting it down there to the public and not understanding the implications of these high-handed kind of decisions. So that is why this act came into being. So now the court here held that actually it may not be reviewable under PAJA, PAJA, and the trustees' resolution was not an administrative action, as the trustees didn't really exercise a public power or perform a public function, nor did the resolution have a direct external legal effect. So this is like a bit of a legal argument. I wouldn't worry too much about that. What you need to worry about is that the resolution was reviewable under common law. So that court case said, if you find that PAJA does not apply, we're still maintaining that the resolution is reviewable under the common law, These people, the trustees, didn't investigate the facts properly. There was no opportunity for representation of the owner at Unit 107 Legacy Body Corporate, and the trustees just acted arbitrarily and irrationally. They didn't even understand that it wasn't the letting agent's fault. The letting agent had just let it out to a tenant. The letting agent had no knowledge about this tenant's authorization to then go on and sublet it as an Airbnb. So they got all the facts wrong. They didn't properly look at things. So they exceeded their powers in banning the estate agency, this letting agency. And the letting agency were justifiably upset because of this reputational damage. Other supporting cases that say that you can review a trustee's decision would be Body Corporate of Laguna, North Global Properties, and even in a homeowners association, Khyber Rock Estate HOA. So we've got a lot of legal discourse talking to us about taking trustees' decisions on review, and that's why it makes it even more important for you as managing agents, or if you're trustee of your own complex, to ensure that trustees take the right decisions and consider the right decisions. Then though, after this first case, now in November, well, before November, the trustees weren't happy about what happened in that case. So they took the matter on appeal. And on the 5th of November, this month, the Supreme Court of Appeal dismissed the appeal with costs. And there you've got the full citation of the case. So in plain English, what this says is that the Supreme Court of Appeal agreed with the original Western Cape decision. And they said, yes, in common law, you can definitely take trustees on review. There's absolutely no doubt about it. And yeah, that's really where we stand. So that's really a hot off the press case, which I enjoyed. What about the community scheme ombuds service? Where do they get involved? I mean, do you have to go to court now to go and get, the Supreme Court of Appeal costs 300,000 Rand to go up to Supreme Court of Appeal? Yes, you can definitely get the community scheme ombuds service involved. They're not talking about a review, but what they are saying is the CSOS can order the following under Section 39(4)(c) and E of the Community Schemes Ombuds Service Act. Firstly, an order declaring that a resolution passed at a meeting of the executive committee was void or was invalid, and they can put forward whatever reasons they feel. And also, importantly for our cases, CSOS can grant an order declaring that a particular resolution passed at a meeting is void on the grounds that it unreasonably interferes with the rights of an individual owner or occupier, or the rights of a group of owners or occupiers. And that is really where that whole reasonableness, exceeding powers, bias, all of that type of thing, they will look very carefully at the facts and make an order based on that. So the CSOS can honestly come and just overturn whatever order whatever order was there. And I think that's something to bear in mind as trustees. Nothing is cast in stone. If you think you've made a resolution, well, think again. It can take. And so the moral of the story is, trustees must act fairly in accordance with the law, honor their fiduciary duties towards the body corporate, and follow due process. If they don't, their decisions can be reviewed by a court or declared void by the community scheme ombuds service. And we've seen quite a few of these decisions being overturned. We've also seen recently, just to brief you on what's going on the ground, the ombuds service is overturning a lot of rules which are not correct and which are not fair, which are discriminatory, and which are not tailor-made for the schemes. A lot of work for trustees. Sometimes people say to me, well, I don't really want to be a trustee anymore. If you are a trustee out there, please take comfort in knowing that you are close to what is going on in your scheme. I think it's a really noble thing to be a trustee. Keep going. Nobody's going to thank you. We always say that we say thank you. because you're contributing certainly to ensuring that these complexes retain their value. If you're a managing agent, and we've noticed on our Women in Sectional Title platform, then we have many, many portfolio managers utilizing this forum. Keep talking to your trustees, keep sharing information, keep telling them about their obligations, and put it in writing so that they can't come back to you and say that you didn't tell them or you didn't advise them what was going on. Owners want certain things out of their trustees. Owners definitely require certainty. They need reliability. They need an understanding of how things work. They don't want to land up feeling ambushed or sidelined by anybody. And I think that's, it's, even though this little cartoon talks about customer complaints and a customer, don't want surprise and delight, they just want delight. Well, so do owners. And in a way, trustees are providing a service, and service delivery is important. Otherwise, you will get kicked out. Making decisions. How do you make decisions? How do you not make decisions? Well, you certainly don't pray someone else makes the decision. You don't panic. You mustn't flip a coin. Think purple. Think rationally. Again, trustees don't know the Sectional Titles Act that well. They don't have books. They don't have 20 years of experience in sectional title. So I think we need to provide them with tools. And Women in Sectional Title have put together a bookmark. And that bookmark can be utilized in your office or wherever it is. And that bookmark is going to tell you what resolutions require what. So you can look at it in a glance and you can understand it much better. You don't have to go and grab your Sectional Title Schemes Act to look. So if you'd like to order a copy of that bookmark, please email me on marina@bbmlaw.co.za and we'll make sure that we get your bookmark to you. That brings us to the end of my presentation. I think that if there are any questions, now's the time to ask them. We've probably got about 6 or 7 minutes left of this. So if anybody's got any questions, please unmute yourselves and I'm certainly available to answer any questions.
Marina, if I can just go through the chat quickly regarding the questions. One of them, will the slides be made available to the attendees?
Yes, with pleasure. If you'd like it, just ask for it and we'll definitely send you a copy of our slides.
And then somebody asked, what is the cost to get a disconnection order through the High Court for electricity and water? An average cost?
We're looking at about 15,000 Rand. And when you take it to you've got to tax that bill in order to place that amount onto the account of the person in arrears. And when we've gone to court to get that bill taxed, we can get a bill taxed for about 16 or 17,000 Rand. So actually, although the body corporate has to pay the upfront fee to go to the High Court, they would be able to place exactly that same amount of money, if not more, onto the owner's account. For the owner to pay, and obviously you need a certificate to get it at the end, to sell it at the end, the unit at the end. So yeah, we've been pretty successful, and I must be honest, I was quite surprised at how the courts are granting these disconnection applications. I thought with COVID and that they'd be a little bit more compassionate, but I do think that they look at the case. A lot of the time, the guys were in arrears before COVID, and now it's just become a complete excuse, So yeah.
And then Aubrey asked, if the trustees refuse to give the owner access to the contact details of all the owners in the scheme, how does he get 25% support if he can't communicate with the owners?
That's true. Very difficult one. Very, very difficult one. I think, it's tricky. Sometimes I have to say in a sectional title scheme, you could take the matter to court. You could take it possibly on an urgent basis to the community scheme ombuds service. Not sure. In the last while, I've said to people, sometimes you've actually got to walk your talk and go and knock on doors. If it's a scheme where there are a lot of investors and not many owners, you could ask the tenants for the details of the owners. A lot of legwork, but it is, yeah. I know it's a problem, Aubrey, 100%.
And then I had a question as well. do the trustees have the authority to pay for internal damages to a section when obviously the external part of the building was neglected? For instance, if they failed to maintain the window from the outside and all this water came into the unit, damaged property, but it wasn't something that could be claimed. It was over time. So it's not an insurance claim. Do the trustees have authority to pay for those internal damages?
No, definitely not. At the end of the day, an owner is responsible for the internal, the internal part of the unit. And I know it always used to sound to me so unfair that outside damage causes inside damage. So why should I pay for damage to the inside? But that is what the law says. I must pay. So let's give another example. Say my ceiling is bubbling because of a leak occasioned from a pipe upstairs. I must pay for the bubbling, obviously, if it's not an insurance claim, but the owner above must fix the problem from whence it emanates. So he has to fix it. The only time that I might have a claim against that owner upstairs, or if it's a body corporate, if it's from the outside and it's a body corporate situation, is if they didn't do anything when I reported the matter and now the problem was exacerbated over time. They didn't listen to my letters, they didn't take my calls, and now I've really got a problem. Then I can claim against the body corporate, and only then, on either a court order or some sort of agreement with the trustees, be entitled to make that kind of payment.
Okay. And then Shirley asked, those lists that you made of the special resolutions and unanimous resolutions required, was that the full list or just the most popular examples?
Look, I think there are one or two missing. So, for things like demolition, you also need a special resolution, but those aren't things that come up all the time. But pretty much, that covers most of them. I'm very happy to get people to send me more, because it'll be lovely to have a proper set so that people can just be able to access it and see. It's really tricky to go and look it up. Even I find it tricky to go look it up. So, yeah. Mainly.
And then Aubrey asked, who pays for legal costs if the trustees lose the case?
Is Aubrey still, which case is he talking about?
I'm not sure.
Oh, okay. Well, in any legal case that the trustees go ahead with, the body corporate would pay the legal costs, because the trustees are authorized on behalf of the body corporate unless they're restricted and they can't go through money, they can't spend an amount more, or because they can't go to attorneys. But if they do and they're authorized, then the body corporate would pay legal fees.
And so then Shirley asked, if the trustees are grossly negligent, can the body corporate claim against them?
Well,
I think
then
also for legal fees.
Yeah, the wording grossly negligent harkens back to the old act, where they said if you convicted of fraud or you're grossly negligent as a trustee, then you can be sued in your personal capacity. Now that's out of the act. So the new act only talks about breaching fiduciary duty. And yes, I think you do have a duty of care and skill and diligence, even when you're going ahead and going ahead with a legal case. I mean, we had a horrific incident of trustees going forward in a legal case, taking matters all the way to the appeal court, wanting to go to the constitutional court. They must have cost their body corporate at least 800,000 Rand in legal costs. Now, that for me is really, that could be grossly negligent. And if you're going to go to attorneys and go for big court cases, everybody needs to know about it. It's not fair to embark on this huge, terrible course of action. Litigation costs big money. It's really not fair, just for the egos of the trustees.
And then what is the cost of the bookmark?
No cost. Women in sectional title will make that available.
And then do you have any webinar focusing on HOAs and directors?
Not yet, but why not? Let's do it. I'm always be open. We're open to so many suggestions. We want to grow. We want to triple the subscribers to all these webinars within early next year. So if you've got ideas, you'd like to see us address issues, whether they be sectional title issues or not sectional title issues, please let us know. We'd love to know about that. All right.
Is there time for more?
Yeah, one more question, and then we'll call it a day.
What resolution is needed for common property to be converted to exclusive use, not on a registered basis, e.g. on a short-term basis?
Special resolution. Special. Yeah, it's a special resolution.
Excellent.
Yeah, through the contract rules.
There are a few more, but most of the people are asking just for the slides. So should they email you directly, or do you think
You're very welcome. No, you're welcome to email me directly. I've got somebody on it who will immediately dispatch.
Okay, perfect. And the email address again?
It's marina@bbmlaw.co.za. Great. Okay, well, I think that that's it for today. Appreciate where you are, appreciate where you're going, anticipate where you're going, and never forget where you started. I think that's really a good message for all of us today. Thank you again to our wonderful sponsors for keeping us on the right trajectory. I'm looking forward to great things next year. We've got one more webinar coming up where we will, in all probability, discuss the state of the sectional title industry in South Africa. We'll wish you then for the holidays. I really think we all need a very, very good break. It's been a tough year, but in saying that, we never write a year off. There have been many good things that have happened this year. So take care, stay safe, and thank you so much for your participation today.